want to see happen, and don't think that there's any way that the court would be able to guarantee, is that if that report was released, there somehow could be arguments made that it impacts the right for later individuals, multiple, to get a fair trial, to have a fair hearing, to be able to be tried in this jurisdiction. The list can go on and on. And so representing the state of the Georgia and these citizens, I know we do have this common interest. We want to make sure that everyone is treated fairly. And we think for future defendants to be treated fairly, it's not appropriate at this time to have this report released. I, as the elected district attorney, have made several commitments to the public, understanding the public interest around this case. The first was before you were assigned to this case. I said by June of that year, I would make a decision as to whether we would ask for a special purpose grand jury. In fact, I did so in May, which is why they were ruled on in May. I then asked for a special purpose grand jury to last for a year, but made certain commitments. By the end of such year, meaning last year, 2022, the special purpose grand jury's work would end. At this time, in the interest of justice and the rights of not the state, but others, we are asking that the report not be released, because you having seen that report, decisions are imminent.
All right, thank you. And I didn't mean to skip over you, DA Willis. Mr. Wade had mentioned that you would be appearing at some point, but that Mr. Wakeford would be the primary spokesperson. So I wasn't sure of the way in which you all were going to present, but thank you for sharing those overview comments. Mr. Wakeford.
Good morning, Judge.
Good morning.
Afternoon.
We're afternoon now. How are you doing?
Well, just fine, Judge.
Good.
So I understand, Your Honor, I have a question for Your Honor first, and then I understand that Your Honor has questions for me. If you'll indulge me.
I will, maybe.
Your order, sure, that's your prerogative, Judge. Your order actually calling for this hearing made mention of a certification from the grand jury that they asked that their report be published under OCGA 151280. To my knowledge, standing here, I don't want to make comments about the contents of a report whose confidentiality is the subject of this hearing.
Sure.
But I am prepared to say that a mention of 151280 is not in the report.
Correct.
So I'm asking Your Honor what the source of the certification mentioned in your order is.
The grand jurors,
Okay.
but so it's not, you're correct, it's not in the report.
Okay.
It is something that they did after they completed their work.
Okay. All right. Thank you, Your Honor. That was one thing I was not able to ascertain.
Sure.
And I understand you have.
You didn't miss anything, nor was I reading between the lines, or there's a footnote that was omitted.
Okay. And I understand Your Honor has questions for me. I'm fully prepared to engage in a dialogue if that's the way you would prefer to proceed.
Well, let me ask you some threshold questions, because that may help focus the dialogue and also focus the dialogue with Mr. Clyde and Ms. Gaither. I'm trying to understand the basis for the request for non-disclosure. And I'm approaching it from a number of angles. One is the fairly limited scope of secrecy of grand jury work in Georgia. And with that, I'm in particular influenced by the Olson case, where the Supreme Court made plain that their view of the statutory framework for grand juries is that really only deliberations are secret. Now, secret isn't the only touchstone here, but that's what's in the oath, is that deliberations are kept secret. You, had you been present for anything that happened in front of the grand jury, are not bound by any statute or oath to maintain secrecy about anything that happened. None of the witnesses who appeared are bound by any oath. Their oath is simply to provide truthful testimony, not to then not disclose their testimony to the media, their uncle, or anything like that. And grand jurors are bound by their oath only not to discuss deliberations. So unless we, and I believe it's a stretch, unless we somehow stretch to say their final report is their deliberations, then I think we're already outside the statutory realm of what's secret. That doesn't mean something should be disclosed just because it's not secret as part of the grand jury. But going into this, my thinking was everything with the grand jury is secret and there'd have to be an exception. And in Georgia, it seems like it's almost the reverse. It's very different from federal grand jury. And I know I asked you to share some thoughts about how we're going to work with the special purpose grand jurors going forward. And there are lessons to be drawn from federal practice, but not driving our decisions. So talk me through just first this question of secrecy and why, if that's one of the arguments, you think that, well, it doesn't matter what you want to do, Judge, it's secret statutorily, the final report.
Okay.
And then we'll evolve to, well, is it a court record or not? Or this notion that in some eyes may be nonsensical, that a final report is equivalent to a presentment of the special purpose grand jury.
Okay. Yes, Your Honor. And let me say also, if there are questions, I would ask, Your Honor, if there are questions at the end of the hearing today, that I feel that I can request us to provide a written response or more research on, I would simply ask for the opportunity to do that.
Sure.
So in other words, that the report is not, a decision is not rendered and the report is not released at 12:59 p.m. on today or something.
That's not how it will happen.
Okay.
There'll be notice in case there are decisions that want to be made after you understand what the decision is.
Understand. I also will, sorry for all the prefaces, but I have to be a little bit circumspect because I have to talk about this report while attempting not to divulge the contents of the report.
I intend to do the same. So none of my questions will be, well, what about page 6?
Okay.
If there's even a page 6.
Okay.
If the pages are numbered. So that's not, I promise you, I won't be trying to drag you into, oh, but wait, this part here. Well, tell me what parts you think ought to be redacted. That assumes that I've already decided that some part ought to be made public, and I haven't. So we can keep it at the very high level of, and this is not it. If this were the report, why is it secret?
So I'm glad to hear that, Your Honor. I just didn't want to try your patience if I keep talking about what the report could be rather than what the report is. But I'm glad you understand the position that we're in.
Well, and I think it helps because Mr. Clyde and Ms. Gaither necessarily are having to approach it that way.
Right.
They don't know what color paper it was printed on. Is it double spaced or what's in it? And I think by you and me having exchanges at that level as well will make it easier for the different perspectives to share their views.
Right. Okay. So then the question of secrecy, Your Honor, I would say that the special purpose grand jury's report in these circumstances, well, actually in all circumstances, special purpose grand juries are special. We have learned that over the course of the past year. As Your Honor referred to at the outset of this hearing, there is precious little litigation on this topic. And exactly,
they are special. I'm sorry, I'm going to pause you from time to time just because if I don't write my question down, I need to ask it. There are only 2 statutes about special purpose grand juries. And one of them says, use all the other statutes about grand juries unless they somehow conflict. I don't know how they conflict because there's so little in 101, 102. So there are things we know because we look at all the statutory framework for regular grand juries. Same oath. And that oath says your deliberations are secret. Your oath wasn't different if you took one. It doesn't bind you in any way. The witnesses take the same oath, and they're not bound in any way by any sense of secrecy. So, yes, special purpose grand juries are different. They last longer. They investigate in a different way. They cannot hand down a bill of indictment or anything like that. But in lots of ways, they're grand juries. And so I think that needs to guide our discussion. And a regular grand jury per Olson, this is the pretty narrow parameters of what's secret, their deliberations. You can't be in there for them. Grand jurors can't discuss their deliberations. But when they're done, here's our indictment, our presentment, whatever it may be. And so I'm analogizing, perhaps mistakenly, and you can help me work through that. When we slide over here, it's a special purpose grand jury. Those grand jurors ought not to talk about their deliberations, but when they're done, what pops out of the toaster instead of an indictment is a final report.
Right.
I don't see how that's secret based on the statutory framework in which we're working. Again, not dispositive, but you may be able to convince me it is secret because this case or that case, and I know you don't have that case because you would have sent it to me long before, but I'm interested in your analysis.
Thank you, Judge. I guess let's start up here then. And then the first point to be made is that special purpose grand juries can be impaneled at the explicit request of the district attorney, the prosecutor, which is in fact what happened in this case. It was impaneled with the request that they investigate certain matters and also be empowered to provide charging recommendations, if any, to the district attorney, who would then not be bound by those recommendations, but could be advised by them moving forward.
Right. The special purpose grand jury whose report is Exhibit C of the media interveners filing, which was DeKalb, presided over by Judge Scott. Do you know? I don't, which is why I'm asking. Was that special purpose grand jury convened at the request of Robert James, who would be Ms. Willis's counterpart at that time in DeKalb County?
I actually do not know the answer to that question.
Okay. That would be an interesting question to answer.
But I will endeavor to find out.
Okay, me too.
But in this case specifically, I think the specialness of special purpose grand juries in some ways points to how individual they are. So in that case, that's a fine example. The ambit of the authority for the special purpose grand jury in that case was to look into a civil investigation. That is not what this case is about. This case, as we have litigated constantly, and as Your Honor has had purpose to look into constantly, has been a criminal investigation at the request of the district attorney. And the report—
I'm going to pause you for a sec. Page 6, pursuant to the relevant statutes, on September 7th, 2011, the district attorney, so Robert James, requested that a special purpose grand jury be impaneled. DeKalb, Stone Mountain Judicial Circuit voted to approve, entered an order, and thus was created that special purpose grand jury. So structurally, it's the same or similar. DA James said, I need a special purpose grand jury to investigate something. And as a result of their investigation, there was a report and it was published.
Yes, Your Honor. What I'm saying is that in this case, it was requested by the district attorney for the sole purpose of conducting an investigation into possible criminal activity. And that the report, therefore, could consist of several different types of information. There could be a summary of what the grand jury came to find out in the course of its investigation. There could be a list of statutes that the grand jury thinks might have been violated by someone. There could be a list of individuals with accompanying activities that the grand jury believes could have broken the law. It could even get more detailed than that. And so the actual content of the report, I think, gives us some guidance here as to how secret to perceive, or how much respect to provide the secrecy of this report. Because, as Your Honor knows, ongoing criminal investigations have a different understanding as far as court records are concerned in this state. And in fact, records that are part of an ongoing criminal investigation are not subject to public scrutiny. When the district attorney requested that the special purpose grand jury engage in this investigation and provide recommendations if they saw fit, it was as part of at that time and at this time, ongoing criminal investigation. If that report contains information, it is for the use of the district attorney per the impaneling order. If that report contains charging recommendations, that is certainly solely for the use of the district attorney. And I would argue that under the law, what the law tells us under 1512-101, I believe, is that the only required recipient of the special purpose grand jury's final report is you as the supervising judge, except in this case, where it was also the district attorney. Because whether there are recommendations or not, the district attorney has to ascertain that, so has to see the report. So I think that's a lesson right there, in that the content of the report and the nature of the impaneling order in a specific special purpose grand jury can affect how we view it under the law. And of course, I will speak to court records and presentments versus reports in greater detail, but I think that is an indication of what we are operating under with regard to the statutory language. The content of the report should be the guide for this court as to exercising its discretion and how to move forward with respect to secrecy and publication.
But what I follow, but what about the process makes it secret? I'm trying to understand. We need to be guided by the statutes. They're not there for optional consideration, and the deliberations are secret. Are you saying this is deliberations, or you're saying, you know what, Judge, let's table the whole secrecy thing, because I don't think you can stretch the statutes to say the report is secret, but, and maybe this is where you want to go next, the report is not a court record, so we don't get to uniform Superior Court Rule 21 analysis about the public's
That's exactly where I would head next, Your Honor.
Okay, let's go there.
I would flip the question. I would say, in what respects is it secret is one way of looking at it, and certainly I'm sure that my colleagues from the interveners will look at it from that perspective. But I think I have looked at this question as what makes it subject to publication. And there's nothing in 1512-100, 10, or 101 that indicates that there is any contemplation of publication, any special contemplation of publication. And I know where Your Honor's going, because 1512-102 says that Part 1 of the grand jury code sections applies unless otherwise indicated. But 1512-80, which is with regards to publication, applies only to general presentments. And again, the content of a special purpose grand jury report can contain elements of both a general and a special presentment, making it a third kind of thing, a special purpose grand jury report. It's an isolated instance under the law.
Well, I think we may be able to dispose of one term so we don't get too confused. My understanding is that this concept of special presentment has gone away. That basically indictments and special presentments, one and the same. We don't do special presentments anymore. A grand jury can indict someone if they're presented first, if it's not a special purpose grand jury. But in reviewing case law that you've provided and that I received from the media interveners, I got the sense that we really don't even use that term special presentment anymore. You're welcome to. I don't know that. I think it's just going to cloud things a little bit. I think in one corner, you've got charging documents, which this body had no authority to present. And we have a history. There is at least one Supreme Court case dealing with a rogue special purpose grand jury that said, not only do we think you should do this, DA, we've indicted him for you. Thank you, but that's a step you can't take. That's a district attorney's decision to make, and then ultimately a regular grand jury hearing the evidence, deciding whether there ought to be a true bill.
That was a Court of Appeals decision.
Court of Appeals. Either way, it was out of Gwinnett County. That is not what we're dealing with here. So I don't know that we get into special presentment. Why is the final report so distinct that it ought not to be treated as a general presentment, and 1512-80 ought to be so narrowly read that it's only a general presentment, whatever the heck a general presentment is?
That's sort of the problem right there, Your Honor, is that, first of all, special presentments, just to put that to bed, I think the distinction is not only that they are charging, but that they make specific allegations of wrongdoing under the law. So there is a possibility that the report can contain what is essentially a special presentment within it, because they were empowered to do precisely that. So I'm coming back to this theme again. The content of the report should guide the analysis.
Okay.
So the special purpose grand jury was authorized to return a report that was, in all but name, took the form of a special presentment. That's something they had been authorized to do. They were also authorized, I mean, it just says report. They could have come back and just provided a summary of what they heard every day, or they could have provided a 2-page summary of what overall they thought the picture painted for them was. That they're authorized to do any number of these things. And the report can take any of those forms. So a special purpose grand jury report, as we'll see, can take the form of something akin to a special presentment or to a general presentment, or have elements of either. And where 1512-80 specifically says general presentments, I don't think that we can say it applies without question to a report issued by a special purpose grand jury. Additionally, I would point Your Honor to 1512-71. That is the duties of the grand jury statute. I got too much paper. Here we go. There's something interesting within this statute, in a couple of instances that was actually pointed out by the interveners in their submission to the court, which is that 151280 is specifically mentioned in 151271 with regard to presentments. What's interesting is that when it appears, the legislature has taken pains to point out that a report or presentment provided as a result of a civil investigation conducted by a regular grand jury is subject to 151280 also. They also later say a decision by a grand jury not to pursue charges or recommend charges against a peace officer who's been accused of an unlawful use of force is also subject to 151280. That report or presentment is. If they recommend that charges are pursued, they can recommend it by either requesting an indictment or a special presentment. So in these other places, the legislature has not assumed that 151280 applies to any report that a grand jury is empowered to produce. When they have to produce these two reports, as they are required to under the law, they have taken pains to say, oh, and 151280 applies. And that is within Part 1 of the grand jury code sections. Part 2, which says that unless contradicted, everything in Part 1 applies, there's just no mention of 151280 in the special purpose grand jury statutes.
There's not. They don't mention any other statute from that first part. They simply say all of the first part is incorporated insofar as it's not specifically in conflict.
And the other term, well, and specifically in conflict, I would say the term they use is report. It is not general presentment. Okay. Now, I understand the position of the interveners. We're not closing our eyes to their position that, come on, there's no distinction between a report and a general presentment. I would refer you, though, to where I began, which is that in this situation, the law has created a situation where a special purpose grand jury can return something that is either special presentment, a general presentment, or has elements of both. And so it cannot just be considered to not be in conflict with 151280, which says general only.
If it has elements of both, then are the general presentment elements publishable at the special purpose grand jury's direction, but not the special presentment parts? Because I want to move away from labels. They called it a report. They could have written on their general presentment. I think you would still be arguing what you're arguing, even though they called it a general presentment, and thus literally under 151280, you say, hey, the court shall publish, other than ultra vires stuff that I am empowered to take out. They called it a final report. I told them to call it a final report. You asked for a final report, so that's why it says final report. But what if there are, as you said, it can contain components of both. If there are things that call out at you as general presentment, then what do we do with 151280?
Right. And at that point, if it's not something that can be considered solely a general presentment, then it's not a general presentment under the law. So, I mean,
a hybrid presentment?
Hybrid. It's a special purpose grand jury report. Okay. It is. We have a special purpose grand jury statute that makes a special purpose grand jury that produces a report. These are isolated under the law and therefore fall outside of the general understanding in certain instances. One thing that's also not in 1512-100 or 101 is that a special purpose grand jury cannot indict. So 1512-102 says all the rest of the first part applies. It doesn't say they can indict. And so the Court of Appeals, in its wisdom, has decided, well, that means they can't indict. So just because these two statutes are brief and you have the catch-all statute does not mean we are incorporating every single component of Part 1 unless there is something glaringly obvious. It actually takes a lot of analysis to look into this. And I think where the choice of words is report and where the report can take on this sort of strange hybrid form, that you cannot assume that the general presentment as used in 151280 applies to a special purpose grand jury report. I think the content of that report, again, is going to guide this court's analysis as to how really to look at that. And that ultimately, if there is something that isn't clearly a general presentment, that 151280 cannot apply.
Okay.
I also think that leads to the conclusion that there's just a discretionary aspect here. And that is something that Madam DA was actually speaking to. If there are recommendations, the district attorney requested those And if there are any in there, or if there are not any in there, the district attorney in its ongoing investigation has to assess what has been provided by the special purpose grand jury. This report was issued 10 days ago. I'm not even.
I don't remember when we had our handoff, but it's recent.
It's extremely recent. There has been no opportunity whatsoever for this office to incorporate anything in the document into an ongoing investigation in a meaningful way, and to make the ultimate decision that only the district attorney is empowered to make, which is either there will be the investigation is over and no charges will be pursued, or the investigation is over and charges will be pursued. And where the express purpose of the report is to investigate a set of circumstances and provide or not provide recommendations to the district attorney, we think immediately releasing before the district attorney has even had an opportunity to address publicly whether there will be charges or not, because there has not been a meaningful enough amount of time to assess it, is dangerous. It's dangerous to the people who may or may not be named in the report for various reasons. It's also a disservice to the witnesses who came to the grand jury and spoke the truth to the grand jury.
So how does one reconcile this perspective with the parallel, highly public proceedings with the January 6th Commission? Many of the same witnesses, hopefully saying similar things if they were asked the same question, but that's not my business. And the commission actually referring to the Department of Justice, you need to look at these people for these things. Dangerous? Pressure on the Department of Justice? They seem to withstand that, and they're doing what they're doing. Maybe they'll bring charges, maybe they won't. Those were recommendations. I think, again, they're called referrals, but clearly Congress, one branch, doesn't tell the executive, DOJ, the other branch, another branch, what to do. But there was nothing clandestine, secret, tucked into a report that the public didn't get to see about that process. And that's different. That was not a special purpose grand jury. But that is another situation that has been ongoing that I think I need to assess and reconcile with how it's happening here. Our legislature didn't choose to have hearings like that. And so the way the district attorney explored it was through the one means she had, a special purpose grand jury. Parts of it secret, some of it maybe not. But this danger and impact, balance it against the fact that the January 6th Commission seemed to do what it did, and DOJ didn't have to shut down after those referrals came.
Well, first of all, they were looking at issues in a different light than the special purpose grand jury was asked to look at them. Obviously, Congress addresses the entire nation. Special purpose grand jury is focusing on Georgia and possible criminal activity within the state of Georgia, or that touches upon the state of Georgia. Additionally, Congress doesn't have to contend with 15, 12, 100, 101, and 102. And I'm not being funny. I mean, like we are traveling under the law here. So Congress, if there's danger created because they are not bound similarly by concerns of grand jury secrecy or traditional secrecy here, I'll put it this way. Congress was going to conduct this investigation because Congress can conduct investigations. That's something it is empowered to do. It was not conducting an investigation at the request of the Department of Justice to provide it recommendations which would inform its ongoing investigation. That's what happened here.
Okay.
So
But I guess the point I'm making through that observation is well, it's two. One, I don't know that you've pointed to any law that says the final report must not be disclosed. Reasons for it, policy reasons, but it may not, must not. I don't think that's what statute or case law says. And so I think it's going to be a balancing, and I don't mean the balancing of Rule 21. We may get there. I'm not saying that's where we are. But I see nothing that says thou shalt not disclose. And so some of the very powerful policy arguments that I've been hearing from you and from the district attorney, well, you need to be thoughtful about lots of stakeholders. You and I both heard the district attorney whisper dangerous, and then you said dangerous. And I was merely observing that a parallel process occurred in Washington, D.C., and the world kept spinning and referrals were made and DOJ processed that and they're going to do what they're doing. And clearly they didn't feel like, well, we better do something right now because very publicly the January 6th Commission referred certain charges against certain people. So if an argument you're making, the district attorney's office is making, no matter who the person is, but that your office is making is, look, it may be post-indictment, it makes all the sense in the world to disclose the report. But before then, you're hamstringing an investigation, maybe putting inordinate pressure on someone. I get these things, but that doesn't seem to have caused the wheels to fall off the DOJ bus.
Well, we don't know, Your Honor. We don't know because the DOJ operates in such complete secrecy, and their grand jury proceedings are subject to much more powerfully secretive requirements. So frankly, we don't quite know the answer to that question. Additionally, Congress's proceedings happened in public. They were nationally televised. They had witnesses come and testify to the entire nation. And then so when they made recommendations, it was based on information that they were publicly releasing, sometimes live and in living color.
Understood,
So
but if Fred Jones was testifying up there and Fred Jones came down here, I mean, that's the only point I'm making is that some of this, well, we don't know what happened in the grand jury insofar as there's overlap. I mean, maybe people do, and things, but we don't need to get into that. You've shared with me your perspective on how, I understand it, how January 6th Commission was different and the fact that they very publicly referred certain charges against certain people to the Department of Justice is sufficiently different that you don't think that there should be a parallel drawn with the concerns here.
I would also add, Your Honor, that while by the necessity of the laws governing serving subpoenas in different states, some of the witnesses have been made public, but the public does not know who the witnesses were for the special purpose grand jury.
That wasn't my point. I agree. That's not my point at all. I wasn't about to provide a lit. We heard 75. We heard a number, but not names. I was merely observing that the public actually does know a fair number, and some of those names overlapped with the very public presentations to, or refusal to share thoughts and ideas and testimony with the January 6th Commission. We can move past that. Talk to me about court record and Rule 21. Why is this not a, you may have already answered it because you were analogizing it, I think, aptly to, it's an investigative report. And if a detective wrote a final report saying, I recommend this person be prosecuted for this homicide, that is not something that the public has traditionally enjoyed right of access unless and until it's part of discovery or it's introduced as an exhibit at trial.
I think that is exactly how to conceptualize of the report at this time, Your Honor. I also want to highlight a point that you sort of alluded to a couple of minutes ago, which is that the time for this conversation really should be after the district attorney, like what to do with the report, what is the nature of the public or secret nature of the report should come after the district attorney has had an opportunity to state, I am not pursuing charges, or I am pursuing charges, or even I have sought charges and here is the indictment that has been true billed. At that point, the relative stance, the status of everyone involved will be much clearer, and we will have a much better roadmap for how to handle secrecy or publication. So I actually think that this entire conversation will be better handled after that decision is made, which the district attorney began by stating that when she has made assurances as to timeframe, she has held up or exceeded those assurances. But I also want to point to another thing. The statute regarding court records is very specific in that ongoing criminal investigations are not subject to public scrutiny. There is no presumption of public access to those. This, we think, commonsensically falls in with those.
When you say the statute, you're not referring to Rule 21?
I mean, Rule 21.
Okay.
In Gwinnett County Grand Jury, which is cited, I believe, by interveners in their submission, actually clarifies that with regard to the kinds of civil investigations which regular grand juries are empowered to pursue and which they can produce reports or presentments as a result of, and which the statute says specifically 151280 applies to. They say that the term court records as used in USCR 21 encompasses only the presentments made by the grand jury in open court at the conclusion of the grand jury's investigation. There's a longstanding requirement for which documents must be presented in open court, including special presentments and indictments. Here, the report under 151271 had to be presented in open court and actually already had been. That is not a requirement under 1512-100 or 101. Their only requirement for the final report is that it go to you as a supervising judge. And then in this case, go to the district attorney as the recipient of either a recommendation for charges or no recommendation for charges. So there is no open court requirement for special purpose grand jury reports. It's just not there. And the Gwinnett County case points to the fact that the presentments, it's not just that they're presentments, it's that they're made in open court that makes them a court record. You couple that with the presumption that documents attached to an ongoing and criminal investigation are not subject to a presumption of public scrutiny or access. And I think it's clear that the report in this case is not a court record as contemplated by Rule 21. I think it's another indication that discretion and the wise choice at this time cannot be that it's released at this time. And everything about the nature of this report indicates that it is premature to make the report public at this time. That I think is the strongest stance I will take before Your Honor today.
Okay. Let me throw a little bit of a wrinkle at you. What would prevent a special purpose grand juror from reaching out to the media saying, I'll tell you what's in the report? Other than me telling them, but what would be the basis for me telling them that? Because it's not deliberation. So we can step back from presentments and Rule 21 and all these things. It's not deliberations. Maybe it's investigative. It is investigative. Maybe it's disclosable. Maybe it's not. Maybe it's disclosable after the investigation is done. That's the reasonable rule you're proposing. But now I am special purpose grand jury member McBurney, and I disagree with that approach. I'm not going to tell you our deliberations. I'm going to tell you how we came up with what we came up with, why we did. I'm going to tell you what several witnesses said because I didn't like what they said or I really liked what they said because their testimony isn't protected in any way. Why could that not happen? Or on what basis could I forbid it from happening so that there could be contempt if it did happen?
Because the report is the necessary result of the deliberations of the grand jury.
So is a jury verdict, so is an indictment, so is a general presentment or a special presentment. It's the synthesis of, it's the end product of, but it's not the deliberations. And that's where, if we end where we began, our part of the conversation, that's what Olson is all about.
Right.
It's just the deliberations. You can't be in there. I can't be in there while they're deliberating. What happens, what goes into it, witness testimony, you actually could have had 5 assistant district attorneys in there, even if only one of them was asking a question. No harm, no foul. Once they're done, again, why is it not something that is disclosable? And if they can disclose it, why wouldn't it then just generally be disclosable? And that's sort of the end of the curveball.
Right. So
you hit it or miss it.
All of the results that you mentioned, like an indictment or a verdict, there is a requirement under the law that those be made public. We're going around in a circle. There is no requirement under the law that the special purpose grand jury be made public. There is not a requirement. And again, we're going to see that the interveners will likely come at this from the angle, well, there's nothing that says it has to be secret. Well, we're saying there's nothing that requires it to be public. It's its own document. And Your Honor could forbid them from speaking about its contents because right now it hasn't been published in open court. It's not in the possession of anyone in the state of Georgia or in the United States of America other than, briefly, Your Honor and the district attorney, who is engaging in an ongoing criminal investigation. And So it hasn't been publicized. It hasn't been released. There's nothing that indicates a requirement that it be released. And the only result of a grand juror talking about it would be to shed light on deliberations and also, in the bargain, interfere with the ongoing criminal investigation, which their report was meant to be a part of.
So what odds do you give an appeal of an order that I would enter forbidding them from talking about the contents of the final report? It gets appealed, restraint of speech, First Amendment violation, and special purpose grand juror X just sends the Supreme Court or Court of Appeals Olson. How's that going to play out? Because I appreciate that I could do things to help maintain the investigation and not get it prematurely derailed by things that it ought not to have to deal with until the time is right. And that's a decision that the district attorney and her team would make as to when the time is right. That's an important interest to uphold. You got my full support of that interest. But I don't know. I need to think through how that plays out. And if we have a grand juror who says, that's fascinating, you're not going to release the report, but I'm going to talk. I muzzle you. I suspect there'd be an appeal. I'm not interested in entering an order that we know is DOA, dead on appeal.
So Your Honor, respectfully, one thing I refuse to do is ever handicap odds of what the Court of Appeals will or will not do.
We do that all the time,
but
and we're always wrong.
Well, that's exactly right, Your Honor. But what I'm saying is that the district, can I actually confer with the district attorney?
Sure, please. And you're almost done.
Okay.
Future defendants so you agree with that? We're not open it forever. Yeah.
So there's two things I wanted to highlight, and I appreciate you letting me confer with Madam District Attorney.
Not a problem.
The first is that our position should not be understood to be a blanket opposition to release of the report forever and until the end of time.
I have not heard that once.
Okay.
I have heard I think, reasoned approach of not now, and here's why. Likely later, and here's why. I haven't heard forever bottle it up. So that's not my takeaway from what you've been saying.
But to your question about what will a future appellate court do, I think that's an extremely relevant fact, is that this is not an opposition that is intended to march to the end of time and prevent public disclosure of what's in this report forever. That's not the position. It is simply saying that now is not the time and that Your Honor has the power to pursue that. Additionally, there are
it's like a temporary sealing. We're going to seal this to include seal the mouths of some people until, and that may put some additional pressure on to reach a finish line sooner, but it's not the same pressure as actually here's the report. And if it says certain things, that complicates and maybe compromises a more thoughtful approach to charging decisions.
I think that there is a clear time to have this conversation when we have a much better idea of how to proceed. And it is after the district attorney has announced either we will not be pursuing charges or we will, and here they are. Mm-hmm. That I think is really what I'm saying. But additionally, there are other constitutional rights that are impacted. And those are the rights of anyone who is possibly named in the report.
So I'm going to ask the media interveners about that, but I guess we can end with that. So let's say that your special purpose grand juror X says, you know what, Oscar the Grouch should be indicted. I mean, we talked about it, and my gosh, Oscar the Grouch should be indicted for treason, if that's a state crime, for inciting a riot based on what happened here in Georgia. What's Oscar the Grouch? Who's he suing? What constitutional rights is he going to be invoking to say, wait a minute, I can't believe someone said that? And of course, the someone isn't the district attorney. It's not you. It's either in the report because it's published, or it's coming from someone who is not bound by any oath of secrecy to not talk about witness testimony or the final decision of the special purpose grand jury. Because the DA brought this up as well, and I get it in part, but I'm crystallize it for me. So what does Oscar the Grouch do? He hires a lawyer, and that lawyer has a conference, a press conference, to say we're outraged and we'll prove our innocence, even though we don't have to prove anything because we're innocent until proven guilty.
Well, we know that the cases exist, which Your Honor actually referred to in your order, where there were discussions of public officials seeking expungement of statements made by grand juries that were different in color than a special presentment or an indictment. So I guess the simplest answer to this question is I'm not totally sure, but we can avoid that question entirely by not publicizing the report until after the district attorney has made public her decision.
Why tangle with it if you don't have to?
Exactly. There's just no reason when the report is sure to be eventually disclosed, because the district attorney is not going to forever oppose it. There is no reason to contemplate the release until there has been a public decision made by the district attorney of the three options I have mentioned many times. We're not pursuing anything. We plan to pursue something, or we have pursued it, and here is a bill of indictment. At that point, we have a much better idea. We don't have to worry about statements made about individuals, because there will either not be any, and we have a better idea of what to do, or there are, and they are contained in a bill of indictment.
Right. If Oscar gets indicted and it's released and it says Oscar should have been indicted, so I told you so. If Oscar's not indicted and the report said he should be, then someone could choose to explain from the district attorney's office why Oscar the Grouch wasn't indicted, but there isn't that cloud hanging over Oscar's head in the interim.
That's precisely right.
Not sure that it necessarily invokes constitutional rights, but I get the policy concern.
And it also marches in lockstep with the concerns about an ongoing criminal investigation. It sidesteps all of those problems. It also solves the issue of, is this a general or is it a special, or is it's sort of, everything becomes clearer at a later date. And we can come back and discuss it in the clear light of day, as opposed to a lot of me standing here and going, well, it could be this and it could be that, and you agreeing that it could be that or this. And sort of, I think the main point is that today is not the time, now is not the time, but eventually we will have a better idea of when the time will be. And that the district attorney's office is not opposed to the eventual release. It's opposed to it right now, and it's opposed to releasing it without very careful consideration in light of all the other factors that are in play. And I just ask Your Honor once again to consider the content of what the actual report ends up being, because the law has set up a situation where it could be a little of this, a little of that, or something completely different. And I think that's part of the reason why we're here, is to sort of get an idea of what are we even dealing with. And I would ask again, if there are further points of law, points of policy, or any other position that the district attorney should illuminate, that you allow us a chance to dig in on that and provide a written submission. Otherwise, I remain available to answer any other questions.
All right. Thank you so much.
Thank you, Your Honor.
Appreciate it. So, Mr. Clyde, your clients are going to get the report eventually. Can we go home?
No, Your Honor. Obviously, we believe the report should be released now and in its entirety. And that approach is consistent with the way the American judicial system operates. In other words, it is not unusual for a district attorney or a prosecuting authority to be generally uncomfortable with having to release information during the progress of a case. That occurs all the time. But the judicial system, time and time again, has said, when matters are brought to the court system, we are going to require them to be made public, because the faith of the public in the court system is much improved by operating in a public way. And so it's only in the most extraordinary situations where our appellate courts and where the United States Supreme Court has allowed the sealing of records, and including, as you articulated it, the outcome of grand jury activity. We acknowledge the operations of the grand jury while it was ongoing were subject to a veil of secrecy. But that, as the court has explained, that has come to an end, and they've issued a final report. And that final report is the outcome of a judicial process, not an executive branch criminal investigation. They invoked the judicial process of the special purpose grand jury statutes. And now that special purpose grand jury has issued a report, and the jurors themselves have asked for it to be published. There's enormous public interest in what they have said, and that exists in this state. It exists across the nation. It exists beyond the nation. And we believe the statutory law supports its public release right now. We believe the case law supports its public release right now. And we believe constitutional law, including our own state constitution, requires its release right now.
So why isn't this one of those extraordinary circumstances where disclosure wouldn't be the standard? I appreciate that you're characterizing it as a judicial proceeding because, of course, a judge had to be appointed to supervise and ultimately receive the report. But I don't think Mr. Wakeford was misdescribing it all that much. And he didn't use the word conduit, but it basically was, here, Judge, here's our report that we've prepared ultimately at the request of the district attorney to answer the questions that the district attorney had, not the court had. The court didn't sua sponte, it could have, but it didn't. To be clear, in this case, we want to know more about what went on with the general election in 2020. That was something that the district attorney asked for, had to pull some levers to do that, judicial levers.
Yes.
But it was executive branch saying, we want to investigate this. The mechanism by which we investigate it is a grand jury. Okay, that means the courts have to be procedurally, not substantively, but procedurally involved. And then we get our report, we, the district attorney's office, so we can figure out what we're going to do next. How is that? That is how things flowed. And it did pass through a court proceeding because I had to swear the jurors in and whatnot. But it wasn't a trial. It wasn't a hearing. I didn't issue any ruling. So I'm
Your Honor,
pulling it out of that framework and wondering how you say, no, it needs to stay in that framework, or at least why is it not one of these extraordinary, uncommon situations where it's really not a court record that came out? I haven't filed it. There's nothing that says I need to file it, which is usually when you are invoking, I ask you a bunch of questions, but it's pent up. And so you'll get to answer. Rule 21 kicks in usually because there's something in the docket that your clients can't get their hands on. There's nothing in the docket. There's not going to be anything in the docket, I guess, unless I decided that something needs to be published, and it'll probably be published by putting it in the docket. There's no requirement that it go in the docket. So there isn't even a court filing that we're talking about.
okay,
I'm done.
I see that as
That was a
three,
fire hose.
I asked three questions and I'm going to answer them in order. Number one, I understand your analogy that this is a conduit situation, and I'm going to speak to that.
Okay.
And then I'm going to speak to why there's really no circumstances. There's none of the extraordinary circumstances that would justify sealing, and why, in the end, this is a Rule 21 document. And so let me start first with, this is a judicial process. And I understand Your Honor's point that it was requested by the grand jury, but it's actually an extraordinary judicial process. In other words, it is, that request is made to this court, and this court's, this, not just Judge Robert McBurney's courtroom, but the Superior Court of Fulton County's power is invoked. Grand jurors are required to come to this courthouse. And that can't happen until a majority of the Superior Court judges agree that this is a worthy thing to undertake. So it's actually an extraordinary exercise of judicial power. And so I don't think it can be characterized as just we helped out the executive branch. It is fully invoking the judicial branch's power and requiring jurors to come and devote their time and their energy to carry out a purpose for this court system. And that is the kind of environment where the case law says, that's judicial. So the next question you've asked is, all right, well, isn't this one of those extraordinary circumstances? And respectfully, I don't think the state has made any showing of any substance that there's one of those extraordinary circumstances. And let me explain that. I respect the district attorney's statement about the protection of other people. And that is an admirable statement for any district attorney to make. But other people, particularly the other people that were involved in this grand jury, are represented by their own counsel. This hearing took place, was widely publicized. Their counsel aren't here. The risk of prejudice to them is actually much less than it is with many, many documents that are disclosed during the judicial process. Indictments get entered, as the court is very aware, indictment get entered by the state or by the federal government with a great deal of detail, sometimes press conferences that drive defense counsel crazy. But there's never been any suggestion, and there couldn't be, that process should be closed. Hearings take place about the exclusion of evidence or the exclusion of witnesses. All those hearings take place publicly. The documents related to them have to be disclosed as court records. Those are much closer in time to a trial. So there's a much greater risk involved in those documents. Here, if we're talking about risk to potential defendants facing a trial years into the future, that this document doesn't rise to the level of the routine kind of documents that are disclosed publicly during the judicial process. So I don't think there's a compelling case for protecting other people's rights. The court asked about, well, who does somebody sue? The court's exactly right. They can't sue anybody. Long ago, the United States Supreme Court in 1976 in Paul versus Davis said, no, government institutions are going to make statements that have negative impact on people's reputation. That alone will not ever create a cause of action. You have to show something called stigma plus. There has to be a deprivation of other kind of rights. Simply reputational interests aren't enough. So what the state is pointing to is simply not the kind of information that justifies sealing. And there hasn't been any suggestion, any evidence, any presentation that really makes a compelling demonstration that there should be a sealing in this case. Ongoing investigations, obviously, when people are indicted, they don't necessarily close. They continue throughout a case. And so ongoing investigations frequently continue after there is significant disclosures of information about an investigation. That's exactly what would occur here. As the court has pointed out, the House of Representatives January 6th committee also has disclosed enormous amounts of information. There's really no precise showing that can support the kind of sealing that they're asking for. And finally, the court asked, all right, Rule 21, really, why is this triggering Rule 21? It's not filed. And Your Honor, it is filed for purposes of Rule 21. And let me explain what that is. For purposes of Rule 21, the question is not whether it's submitted to the clerk. The question is whether it is submitted to a judicial officer that needs to take action on it. And that's what triggers Rule 21. I'll give you a case cite to that.
Please.
And we're happy to provide more authority on this issue. And this is, I'm going to give you Forsyth versus Hale. It is at 166 Georgia App 340. And I'm quoting a part of it here. A paper is said to be filed when it is delivered to the proper officer and by him received to be kept on file. In this case, that special report was by law submitted to you as the supervising judge. Based on that, immediately you had responsibilities. You had to provide it to other judges and everybody to reach a decision about whether this grand jury could be dissolved. There were decisions that had to be made. The power of this court was invoked. The decisions by you as the supervising judge had to be made. And so overall, it falls exactly within the category of Rule 21. Now, I acknowledge that there's a secrecy with respect that the Gwinnett County grand jury decision recognized there's a line that the records that the grand jury looked at during its ongoing process are not accessible as court records because historically they haven't been. But then the Gwinnett County, the Supreme Court or the Court of Appeals in the Gwinnett County decision, the Supreme Court in the Gwinnett County decision emphasized in that case, that general presentment had to be made public because it was the outcome of their process. And so it was subject to Rule 21, and essentially the same process would apply here.
And was that grand jury a special purpose grand jury or a regular grand jury? Because regular grand juries can do general presentments as well. They're empowered to investigate the clerk's office, and they could, not going to indict the clerk, but they could say, hey, we noticed that they use too much paper in their copy machines and we should be more environmentally conscious.
Exactly.
So the case you're referring to, there are lots of Gwinnett cases, so I'm not necessarily seizing upon the same one. Was that a special purpose grand jury in which the Supreme Court said that, I know they used the term general presentment, and we'll talk a little bit about report versus presentment, but setting that aside, they were saying that special purpose grand jury's general presentment must be made public because it is effectively a filing.
Correct. And it was a general presentment from a grand jury and in a civil context. And I'm talking about the 2008 In Re Gwinnett County grand jury case.
Okay.
Justice Benham held that that document was subject to Rule 21. And we would submit the same thing the same conclusion would be reached with respect to the final report. Your Honor has, and I understand the questions relating to 15-1280, and we're eager to address that. But one of the things that I want to emphasize, and I think from the court's questions, you fully understand this, but that those are two independent bases for the disclosure of the report.
No, they are, and I press Mr. Wakeford on them because it's sort of mounting pressure, if you will. The grand jury itself said you need to publish it, and if one travels to 15-1280, actually is a shall. There are not a lot of statutes that say the court shall. That's the court shall, and I've learned what that means. If it applies, if 80 applies, but I appreciate that that is a separate basis. If I were to find that the final report is effectively a Rule 21 filing, then Rule 21 and all the case law that you and Ms. Gaither cited that talk about the competing interests, and it really is extraordinary and exceptional not to disclose something that would fall under or within Rule 21's ambit. So that would be a separate and compelling reason if I were to find that the final report is a Rule 21 filing.
Exactly, Your Honor. And if I may add one item to your desk is today we're also going to provide the court with another example of a special report that was published. This is, and this is a copy. I'm going to provide a copy to you in just a moment. It involves the Gwinnett County Grand Jury, and it is from 2009. It was them looking at land transactions. And Judge Clark, at the end where I put that map,
You may.
Where I put the blue tab, is where Judge Clark has ordered this special purpose grand jury report to be published in the legal organ. So it is an example, and I would say that just as in a sense, I would think that the two special purpose grand jury reports that are before the court are in a sense examples of the two ends of the spectrum. Obviously, in the DeKalb special purpose grand jury, they recommended prosecutions of named individuals. And that was disclosed and published by Judge Adams in the DeKalb situation. In the Gwinnett situation, this is a grand jury that found a great deal of discomfort and criticized various aspects of the land purchasing decisions made by Gwinnett, but generally is not recommending prosecutions, is moving in the other direction. But in both cases, they were published in their entirety at the direction of the supervising court judges. And in both cases, these are special purpose grand juries.
So these would be then examples that it is possible to do it. And I assume if it had been legally challenged and a higher court had said the trial judge was in error to do that, then Mr. Wakeford would have shown me those opinions. So those aren't out there. But what about his argument that if, I know you don't know the content of the final report for lots of good reasons, but what about the argument that the content should drive the decision-making process?
So Your Honor, I'm going to address.
Or did I interrupt you before you got all the?
But you raised another issue that I'd like to just cover, and then I will directly answer that question.
Okay.
With respect to the DeKalb special purpose grand jury, and the court may already be aware of this.
Yeah, full disclosure, I was a brand new judge, and all of a sudden, Mark Scott, defendant, was in front of me. There was a whole lawsuit that came out of DeKalb about not handing over that report to the rest of the bench, and so I'm a little familiar with how that was. Nothing about publication. That was news.
I understand.
I wasn't interested in whether it was made public. I was interested in getting Judge Scott out of my courtroom.
And the only thing I wanted to point out is Burrell Ellis is ultimately prosecuted for perjury in the aftermath of that special purpose grand jury based on his testimony that was presented at that special purpose grand jury. He's prosecuted. He is verdict. He's convicted at trial, and he ultimately, on appeal, parts of his conviction are affirmed, parts of it are reversed. But there's nowhere in that opinion, and that opinion does recount the history of the special purpose grand jury, that it is any way critical of the release of the report, nor did Burrell Ellis and his counsel ever make any argument that the release of the report somehow put him in an impossible position at his trial. Obviously, as the court has pointed out, there hasn't been a decision directly on point with the issues that we're taking on today. But it is an example of somebody who was prosecuted in the aftermath of the release of a report, and it never rose to the level of an issue worthy of appeal. Then, Your Honor, I'm going to address, I apologize, I'm having trouble remembering the.
It's all right. It was the question, Mr. Wakeford was making the argument that we could, when I was exploring report, special presentment, general presentment, that really depends on the content of the document. And the more it is like a special presentment, the more it is something that is an investigative tool for the district attorney, as opposed to a general report on here's the things we learned and saw and whatnot. That would militate towards not disclosing now, because it's much more like a detective's homicide report. That's not a court filing. That doesn't get filed with the court, but that's someone thinking long and hard about, should the district attorney bring charges against someone for killing someone?
And Your Honor, in terms of suggesting to the court that it has discretion to make independent judgments about what should be public and what shouldn't be public, I do not believe that that discretion exists in anything other than the law of Rule 21 and the law of essentially expungement of ultra vires activity. In other words, what do we believe the case law supports? We believe that the court is within its rights to read the report if this grand jury, and occasionally that happens, if this grand jury has gotten outside the ambit of its mandate and made statements that have nothing to do with what its actual role was, that is appropriate for expungement. We aren't arguing, we aren't disputing that. We only note that by implication suggests everything within the scope of their mandate is supposed to be made public. The second part is does the court have authority to seal under Rule 21? Absolutely, it does. But it has to meet the Rule 21 standards. And there's the argument that has generally come from the state today is it is uncomfortable, this report being released until we've made these decisions. And I don't fault the expression of discomfort or
I fully understand it. I think it is a reasonable concern to raise, but if I find that we're within the realm of Rule 21, it's just not one that weighs real heavily in the scale, as I understand the analysis that higher courts have performed. So one doesn't ignore it, but it's a lighter weight than the public's interest and the general presumption that court filings are to be made public.
And Your Honor, I guess we would say it's not just a lighter presumption, it doesn't meet the standard. In other words, the discomfort of the prosecuting authority in disclosing court records isn't enough to make them sealed. It has to be significant, identifiable evidence that's going to cause a problem. And Your Honor, I don't think that submission has been made.
I have a question about that standard. In your brief, page 18, you use the phrase clear and convincing proof. And clear and convincing evidence, that is a standard out there, which is different from a preponderance. It's much more than that. It's not well defined. It's less than a reasonable doubt. It's actually what the JQC has to use for judges, clear and convincing. And that's the phrase you use, but there's a whole lot more than a preponderance. I'm wondering if you have case law for that, or it was just a colorful phrase trying to show that there is a burden that the party seeking to seal something has to meet. And there is, but I'm not familiar with it being clear and convincing evidence. That is a higher burden than I weigh it and find in which way do the scales lean? Where's the preponderance? Sealing and not sealing. And that's why I was saying the district attorney's concern about timing and not having the investigation unnecessarily rushed. I think that is a factor that I can weigh. Your point was my point was how heavily do I weigh it? And you said, oh, you shouldn't, it doesn't weigh as much as the public's interest. It might not, but there are other concerns that the district attorney raised, the rights of folks who may be named in an unfavorable light in the report, if that's how it works. And so I envision the process, the Rule 21 process, to be stacking weights on the scale, just like a jury would in a civil trial. I think that's a fair way to think about it. They're heavier and lighter weights. But in the end, I need to decide, are the scales leaning in the direction of sealing or in the direction of having this be an open record? I think I just need to see that it is leaning in a direction. I don't think it has to be leaning in a particularly strong way. And clear and convincing is that it has to be leaning in a particularly strong way. So that was a long way of saying, where do you get clear and convincing evidence as the standard?
And Your Honor, I believe clear and convincing is the standard for closing a courtroom. I would say the way you've described the sealing of records is correct with this caveat. The items that you are putting on the scale have to be constitutionally cognizable issues. And so in other words, a general statement that people's reputations might get hurt has repeatedly been identified by our appellate courts as not enough, as not even beginning the discussion.
Okay, because they're two different things. Not enough is what you keep saying. And I'm saying, okay, it's not enough standing alone, but maybe there's more other factors. But then you shifted towards the end saying, actually, that's not a factor at all. It would be improper to put that on the scale because it's not constitutionally cognizable. I'm not disagreeing with you. I'm asking you to educate me. Can I put whatever are deemed to be reasonable factors, or there are cases out there that say these kinds of things might be someone's concern, but you may not put them on that scale to decide which way the scales are leaning?
And I would say it's the latter. In other words, that's simply that kind of general articulation of potential injury to reputation simply doesn't make the scale.
It's not a factor to be considered. Whether one considers it lightly or greatly, it's not a factor.
And you know, if there was a detailed showing about an individual made by their counsel, and it was an extraordinary situation. And let me explain.
Stigma plus.
Well, an extraordinary typically involves juveniles, typically involves highly private information. It doesn't involve public officials who are involved in activities following a national election. And so that's the part where the fit is just not very tight. And so that's, but Your Honor also brings up a good point that I would like to react to, is the only organization that filed a brief in advance of this hearing is us. The state has articulated their argument today. We will plan to respond to that argument with more detail. So the court has some of the case law that has rejected sort of generic concerns about reputation as a basis for sealing. Because I do think that is well established. And so what we would submit is when it comes to that weighing process, and Rule 21 itself requires that it significantly outweigh the presumption of openness, that when it comes to that weighing process, that the weights that you can put on the closure side are really not compelling in the situation that's before us here. And then on our side, we are talking about really one of the most compelling situations for legitimate public interest that I can think of in this courthouse. In other words, there is genuine public interest in what these grand jurors found after they sifted the evidence, after they heard from all the witnesses, and its interest, not just because of the role they played on the grand jury, but also because they are community citizens and speaking to these issues from that vantage point as well. And so that's also important and part of the public interest.
What is your response if I'm the special purpose grand juror who's been told by this judge, you can't talk about your final report to anyone. It's secret, or at least I'm telling you can't do it. And they look in the online First Amendment lawyer, Tom Clyde pops up. And so you get a call from a special purpose grand juror saying, judge is telling me I can't talk about deliberations, but I also can't talk about what any witness testified about. And in particular, I want to tell people about this special purpose, our final report, because the judge isn't publishing it, but I want to talk to folks about it. Can a judge tell me I can't? I mean, yes, he can, because he did, but can we challenge this judge, and what's our strategy?
Your Honor, I think they could challenge that. In other words, as the Olson case makes clear, they are now required to take an oath, and that oath was narrowed by the General Assembly. And so they are bound by that oath. Could this court, in extraordinary circumstances, impose what would be a prior restraint on their speech? Yes, in extraordinary circumstances, but as the court knows, the extraordinary circumstances for it to warrant a prior restraint are typically situations that are putting the national security of the nation at risk. In other words, the examples that have been used by the United States Supreme Court are the location of warships in time of war, things like that. That can justify a prior restraint. But here, as long as the grand jurors abided by the oath they were required to take and the General Assembly approved, I think they're within their rights speaking about their experience. And there is specifically a Supreme Court case, US Supreme Court case, that says witnesses that appear before the grand jury are allowed to speak about their experience before the grand jury.
And I think that the Olson case makes that clear. I'm not talking about witnesses. They're going to do what they do. So you contend that that would constitute a prior restraint, say you can't talk about this. Well, what about the notion that the final report is really just an extension of their deliberations? It's not a presentment. It's not the kind of thing that grand juries, it is specifically what this grand jury came up with at the end, but it's not a general presentment. It's not a special presentment. And so really they shouldn't talk about the final report because it is just an extension of those deliberations.
Your Honor,
I'm not really compelled by that
Your
question.
Honor, I think it's a step too far. In other words, as the court has indicated, the outcome of grand jury process, the outcome of those deliberations is a public document, and historically. And so that process of the deliberations end and an outcome gets rendered to the court system is a significant and important step in the process. But I don't think you could seal the final report as being a part of their deliberations. And candidly, I think the statement by the special purpose grand jurors that they wanted their report published speaks to that. I don't think they see it as an exposure of their deliberations. They see it as this is the judgment, and I haven't read it, but they see it as this is the judgment, or the judgment that we've reached. And that's what the court system historically said, that document becomes public. Your Honor, unless you have other questions, I will not take any further of your time, but what we would propose is that just as Judge Adams did in DeKalb, that you order that the report be filed with the clerk's office, and I think the expression he used was spread among the minutes of the court, and that it be published pursuant to 15-12-80.
All right. Ms. Gaither, anything you want to add? Did he cover it?
No, Your Honor, he did a pretty good job.
All right. Mr. Wakeford, I've seen the Post-it notes flying in your direction. So why don't you come on up here and let me hear any brief rebuttal you may have.
Brief, right, Your Honor?
Well, that's what the lawyers always say, and 30 minutes later, we're still hearing it. No, I'm interested in what you've got to say in response, and in particular, touch upon, I'm not familiar with the Forsyth case, 166 Georgia Appeals 340. I'll read it, and I'll look for other cases like it, but I was intrigued by this notion that there's case law out there that one could use to characterize the final report as a filing, certainly not in the clerk's possession right now, and it won't be anytime soon, but because it came into the court's possession, then it's a filing, and we are within the realm of Rule 21 and not someplace you'd rather be.
Right, Your Honor. And I think opposing counsel or counsel for the interveners used an interesting phrase just a moment ago. We progressed away from filing in open court to just maybe sort of filing to rendered to the court system, which is now, we are so far from the language that is contained in the case they cited, the Henry Gwinnett County jury, that we are no longer talking about a presentment made by the grand jury in open court, which is what the language that the court chose, the Supreme Court chose in that case. Additionally, they cite to a portion of the language of that case in their brief at page 11, a block quote from the Supreme Court's language where they talk about Rule 21. And it's at the top of page 11. They say, Rule 21 embodies the right of access to court records which the public and press in Georgia have traditionally enjoyed. And as opposing counsel also pointed out, there's no law on point as to what to do here because there's absolutely nothing traditional about a special purpose grand jury.
Right. No, that's not the strong argument for disclosure, is that this report falls into that category of traditional act. There's nothing traditional about this report or this process. So I get that. That doesn't mean, however, that it falls outside of Rule 21. It's not a simple one, which is why we're having to have this hearing. If this were an indictment, that's a simple one, and we don't have this discussion. Right. And it may be that there is the name of a critical witness that the state is seeking to redact from the indictment until it's appropriate to unseal that piece because people haven't been arrested yet or something. It happens all the time. That's not this. This is different.
Well, I would say that the question of whether Rule 21 is applied in this specific way, going to Your Honor's point, that may be something that requires additional argument from the district attorney's office, because I really think that demonstrates ably that we are not within the realm of Court Rule 21, in that we are much, if we are, this is a document that is much more akin to a piece of an ongoing criminal investigation. But you've heard me a lot on that. I also want to point out that we got to take what guidance we have. And 1512-101 refers to a final report, not a general presentment. In other places where reports are mentioned, like 1512-71, they say report or presentment. That is not the choice that was made in 1512-101. Additionally, there's no open court requirement there. There is only that it goes to the supervising judge, and as we said, in this case, to the district attorney. That seems to indicate something to me that is significant, but mainly that we are not in the realm of a general presentment, and certainly my comments about the content guiding the analysis remain. But let's go all the way to saying, okay, fine, it is a general presentment. Even then, 1512-80 just says that the court shall order publication, but it also empowers the grand jury to direct the manner. And there's no indication from Your Honor that the manner was prescribed by the grand jury, indicating to me that since, once again, the district attorney is not opposing the eternal repression of the report, that Your Honor has discretion about the manner of publication.
Which here would be timing as opposed to, I mean,
Precisely.
no one's fussing about, is it put on the website or is it in the docket? It's really all about the clock. When does it go to whatever place that would be?
Precisely, Your Honor. There could be conversations about specific portions, depending again on what the content of the report is. But really, going back to where we began, this is about time. Yes, Your Honor. That is exactly correct. And since the grand jury's preference has been afforded great weight, as it should be, and I'll take this opportunity to say, the district attorney's office, as I'm sure Your Honor is, are enormously grateful to these citizens for the really above and beyond contribution of their time, energy, and efforts to this process. We want to act with respect to their wishes, but we also have to act as stewards of an ongoing criminal investigation, of which they were a vital part. And so with regard to the timing aspect, we think that since they did not speak to manner, Your Honor has a discretion there if this is a general presentment. And so no matter which route we take to get where we end up it's a question of timing. And now is just not the time. The time will come. And the district attorney is committed to that idea. It's just not immediate.
Got it.
Thank you, Your Honor.
Thank you. Well, I want to thank both sides for being prepared and having these thoughtful presentations. This is not simple. I think the fact that we had to discuss this for 90 minutes shows that it is somewhat extraordinary, Mr. Clyde. Partly what's extraordinary is what's at issue here, the alleged interference with the presidential election. But it's also extraordinary in the plain meaning of that word, is that it's not ordinary to have special purpose grand juries doing things. That doesn't mean, however, that there hasn't been a course of conduct developed over time as to what happens with special purpose grand jury reports or presentments. It also doesn't mean that I can't figure out a way to assess the final report through the lens of grand jury secrecy and the statutory scheme for grand juries, as well as viewing it through the lens of Rule 21 to decide if it falls within the reach and scope of Rule 21. And that's what I'll need to do. My proposal is that I think about this a little bit and then contact both groups, the district attorney's office and the interveners, if I've got specific questions for which I'd like more input. And then you're welcome to file something or provide an email that these are the cases you should look at. I won't dictate the format in which you respond. I will be sure if I have questions, even though they may be for one side and not the other, I won't say side, one group and not the other, they go out to both groups, because I may have a question for Mr. Clyde and Ms. Gaither, but Ms. Willis, your team may want to be heard on that question, even though it is poking more at the media's position. As I said early on, there'll be no rash decisions. There's not going to be an order that pops out with no notice and attached to it is the report. there'll be an order if there's going to be disclosure that perhaps says this is when it would happen, so that both sides have a chance to react and take whatever steps they'd want to take in light of an order that says this is going to happen a little ways down the line. So no one's going to wake up with the court having disclosed the report on the front page of a newspaper. The report, of course, exists in the district attorney's control. So if it does show up, folks will need to work through that. But I will circle back and we'll figure out the best way to move forward with this. Ms. Willis, anything else from the district attorney's side?
No, thank you for allowing us to be heard today.
Thank you for being here, all your team. Mr. Clyde, anything else on behalf of the interveners?
Your Honor, can I speak just very briefly to one of the last things that you mentioned? We understand the court that'll give the opportunity for either side to take whatever action they want in terms of appellate issues. We believe the proper court, if there's an appeal in this case, we believe the proper court should be the Georgia Supreme Court. And we believe the Georgia Supreme Court would be interested if that's the direction it takes. But I will point out to Your Honor that the constitutional argument we are making would have to be reached by Your Honor in order for that to be the clear choice and clearly appropriate court for resolution of the issue. So that is an area we hope the court will reach.
I appreciate your concern, and I think if there's a ruling of non-disclosure, it would need to address the different bases and each of the bases that you raised, that it's not secret, that it does fall within Rule 21. And so I think you'd find the toehold you need to do what you need to do if you feel that that's appropriate to do, if that's the end result.
Very good. Thank you, Your Honor.
All right. Well, that's it. Thank you, everyone. I need at least Mr. Wade or someone. You're welcome to stay, Ms. Willis, but I don't think you need to for the we have a logistical conversation about something. Thank you.